Good morning and welcome to the HRTorQue webinar this morning. We will be doing a webinar on the intricacies of polygraph testing, criminal checks, specifically around the most recent looting and what an employer can do. The presenter today is going to be Dunstan Farrell. He is from Farrell Attorneys. He's been a practicing attorney for 38 years, specializing in employment law, and he's going to be sharing his screen shortly and presenting to us on what we can do as employers and how we can, what we can do from an employment perspective and how we can manage employees who've done things wrong. Welcome, Dunstan. Thank you for being here.
Hello, good morning. Good morning, Nikki. Good morning, everyone. Thank you very much for having me. I just wanted to start with a story, and it's interesting. Before I was going to tell the story, I bounced around the office, and half the employees, the attorneys, and the support staff in the office said I could tell the story in complete graphic detail, and the other half said that I should censor it and be more circumspect. So I've gone, unlike my normal personality, gone with the more conservative view, and I leave the rest to your imagination. But I didn't realize I'd been around for 38 years, so it must have been 38 years ago that I was called to see a new client up in Hammersdale. I was new to employment law, and it was a new client. I was young, and the client wanted to utilize a polygraph to ascertain whether employees were guilty of misconduct or not. And 38 years ago, there was a security business in this country run by a large, square man who ran a fleet of armored cars, and his business was to break unions and to break strikes, and that's how he operated. Anyhow, when I walked into the room, there was a woman very provocatively dressed, his umpteenth wife. My office, the conservative portion of my office, said I was not to describe what she looked like, so I will leave it to your imagination. But she was exceedingly provocatively dressed, and she said, "I am the polygraph tester," and then promptly, despite her provocative look, then put a gun on the table and began to explain to the two employees that she was going to carry out a polygraph test. So that was my first exposure 38 years ago to polygraph testing. My views on polygraph testing since then have not changed that much, and I suppose first impressions are always the strongest. But let me take you through it. Having said that, there's certainly a time and place for polygraph testing, but they are not the panacea for all ills, and they need to be used very circumspectly, as I have used the story that I've told you now circumspectly, so polygraphs must also be used circumspectly. So I'm going to deal with what polygraph testing is, when they can be used in the workplace, and can they be used to dismiss employees, and can employees be dismissed for after-hours activities. I'm going to tell you another story, and I'm great for telling stories. So the looting saga in KZN started, I think it was on the 12th of July. It was a Monday. There'd been rumors and there'd been social media reports of it overnight from the Sunday night. There were a few of us in the office on the Monday morning, a number of attorneys and a couple of the support staff, and our gardener was also here. And by sort of midday, 12 o'clock, we all thought that maybe we should be heading home and to the safety of the suburbs where we all lived, and we all went our separate ways. And then a day or two later, the family of our gardener, the office gardener, had also been here, and he's very much part of the staff. He's in and out of the offices. He makes tea for himself. He makes sandwiches, and he's part of any activity that we have at the office. He's a young man, I think 24, 25 years old. He is the father of two children, his family came to me, I think on the Wednesday or Thursday, and asked me for 1,000 rand for bail, as he had been arrested for being part of the looting. I said, that's fine. I gave them 1,000 rand, and off they went. On the Friday morning, they came back to me and said they couldn't find him. So I then took the family with me, and we drove around from police station to police station, from Westbrook Prison to CR SWAT. And eventually at CR SWAT, I befriended some, and everyone had been very unhelpful until then. I befriended some policemen who said, oh, yes, yeah, we've got his ID number, and he's sitting in Westbrook Prison. And we'd already been to Westbrook Prison, but he was there, and they said they will not allow you to visit, and they will not allow you to take any food with him. He had no cell phone or anything. So, and he will make his first appearance in court on Thursday morning. On the Thursday morning, in fact, then I tried to phone all the human rights organizations that I could find, whether it was Amnesty International, and I had worked with Amnesty International when I was in Edinburgh studying, Lawyers for Human Rights, Legal Resources Centre, Legal Aid, and I could find no one who was particularly helpful. And we knew that there were thousands of people who'd been locked up around the province particularly. No one had been charged. And everyone, the principle that everyone is innocent until proved guilty. I tried my best. And then on his first appearance, I sent a young article clerk down to court, who then organized bail, and he paid his 1,000 rand bail, and he was released. Completely shattered, absolutely shattered. He'd been in jail for 10 days. There'd been 200 of them in a cell. One wonders why COVID is rampant in the province, and that can be only one of the explanations. He'd been in the cell. So we said to him he could come back to work, but for the first week, he couldn't come into the office. So we sort of banished him to the garden and said if he needed tea or coffee or a sandwich or something, we'd bring it to him, not as punishment, but simply to his isolation. And he was desperate to work. He needed the income. And the trial has now been postponed to, I think, September sometime. But that anecdote tells a lot about what happened. And we debated it long and hard here in our office at a very personal level as to whether we should be taking any disciplinary action against him or not. To cut a long story short, he's back at the office. We decided not to take disciplinary action against him. He's very much an integral part of our office, and we all support him. We're all angry with him for what he did. But we'll deal with that scenario as it plays out for other employers. And I'm not saying that we were necessarily right. And there may well be circumstances where individuals who were part of the looting should be dismissed. And I just think quickly there were 2 private school educated men who were arrested, one outside Woolworths in Botanic Gardens Road near the NSA, private school educated. I seem to recall he was driving a big Mercedes, so he wasn't starving. And he is a well-known CEO of a big company. And yeah, in those circumstances, the situation is very, very different. Or where an employee is, and I just use, walking in and he's wearing the bright pink or mauve shirt of Game, and as well emblazoned, and he is clearly an ambassador for his brand. Maybe in those circumstances, disciplinary action would be called for. So back to the beginning, what is a polygraph test? It's a device that measures and records severe physiological indicators to determine whether or not the person is being deceptive. And I think it's important just to dwell on the word deceptive. It doesn't tell me or your employer that you are lying, that you are dishonest, that you are a thief, that you are insubordinate, that you assaulted someone, that you're a rapist. It simply says you are deceptive. And I go back to the picture I painted to you of the provocatively dressed tester in my first experience. I'm also told that people who take these polygraph tests and lie detector tests may pinch themselves or have something in their shoe that they can press. There's a needle or a drawing pin or something So it distracts you, or it just creates the wrong readings. But what the important thing is that it's deceptive, and people who are on antidepressants and that sort of medication, again, these tests are very unreliable. So yeah, go back to the fundamentals. The Constitution, Section 12, we all have the right to security of person. Section 10 and 14 protects employees' right to privacy and dignity. Section 35 protects the right to stay silent. And Section 23 protects employees' right to fair labor practices. So all those aspects of the Constitution have an impact on polygraphs. Something that I think is very important is that your refusal to take a polygraph test, and we'll deal with it because it may need to be contractual, but if you refuse, having agreed in your contract of employment, and some employers use polygraph tests, indiscriminately is not the right word, but randomly and all the time. I know of a client in the security printing industry who polygraphs employees all the time, and as part of your contract of employment, and they just randomly and on a regular basis test everyone because they're in the security business. The argument which I have often, and we debated here in the office recently, is if I can draw an adverse inference from the fact that you refuse to take a polygraph test. The fact that you refuse to take a polygraph test, having agreed in your contract of employment or otherwise, and you just say, well, I'm not going to, and I draw an adverse inference from the fact that you're saying no. Does that suggest that you are guilty of something? And I go back to the principles of the employment relationship being one of good faith. And the recent matter, or it's more than recent now, it's 2 years ago, the derivative misconduct judgment in the Constitutional Court, the DIP matter, which came out of this office, despite the fact that the Constitutional Court said that there is no duty to rat on your fellow employee, the word impimpi was used often, still maintains that there is a duty of good faith. You need to promote the interests of your employer. And there was a long ongoing debate about whether that's an archaic principle of the doctrine of master and servant, and the employment relationship has moved beyond that. And there was a lot of argument about the simple fact that employment is simply, you arrive at work, you've got a job to do, you do it, you get paid. And there's nothing beyond that. But the Constitutional Court has held that you have a duty of good faith to promote the interests of your employer. So if it helps your employer to maintain discipline, why then refuse to have a polygraph test? Or why go and loot wearing your work uniform? Or if you're in a prominent position with your employer. But clearly one cannot compel an employee to take the polygraph test. And I suppose much of the same arguments have been raised now with the issue of COVID vaccines, that people have the right to privacy, the right not to have their bodies impaired by anything, by a vaccine. So yeah, all the same sort of principles apply, but consent is of paramount importance in dealing with polygraph testing. So we dealt with the right to remain silent. So everyone who is arrested for allegedly committing an offence has a right to remain silent, to be informed promptly of the right to remain silent and the consequences of remaining silent, or not being compelled to make any confession or admission that could be used in evidence against the person. We all, I suppose maybe I'm generalizing, but America, the USA, is often held out as this great nation where human rights are of absolute paramount importance. And we've seen recently that, particularly with the Black Lives Matter move, that has not been the case. But in America, polygraph tests are used a lot in criminal matters, and not that I changed my view on them, but they are certainly used more scientifically in America than they are here. Here they are very used in a very sort of cowboy, cavalier manner. In America, the use is much more scientific. It's also quite interesting that I've recently been doing work for a psychologist who has now relocated to America, and his job is to psychoanalyze, for want of a better word, big borrowers of money. And they, from your personality, they will assess, and he will write a report as to whether you, in your personality, are likely to repay the money or not. So they're not really looking at your assets and those sort of things, but they're looking at you as a person, and to determine whether you as a human being, your personality, will honor your debt. So there may be, with the advancements in science and those sort of things, there may be in due course a more accurate use of polygraphs. So the accused individual, whether it's in a criminal matter or in a disciplinary matter, has the right to remain silent, and he also has the right not to incriminate himself. And so it's also, just anecdotally, it's interesting what has gone down at the Zondo Commission, where hundreds of witnesses, hundreds of individuals, including current president, past president, have been called to come and give evidence at the Zondo Commission. But as they all stand there now, they are innocent of any wrongdoing, be it Mr. Gupta, be it Mr. Zondo, and they do have a right to remain silent, because at this stage they haven't been charged or anything. So there's also interesting principles coming out of the national issues about the right to remain silent and the right not to incriminate yourself. So when can a polygraph be used in the workplace? First issue is, importantly, the consent. And we've gone through the constitutional rights of employees. And often an employment contract will provide that the employee agrees to have a polygraph test. And I would suggest that these terms are included in contracts of employment if employers intend to use polygraphs. Particularly if you want to compel an employee to take the polygraph test. Can the polygraph test be used to dismiss employees? And just in summary, the answer is, on its own, no. It is simply of value to corroborate other evidence, and all that polygraph says is that you are deceptive. It does not say that you stole 1,000 Rand out of the petty cash tin. It simply says, when I ask you specific questions, and that's also what's important about the science of polygraph testing, is the questions that are asked. There are a number of test questions that are asked, and then the way that the tester frames the meat of the questions is also important, because that can also lead to difficulties. The employee doesn't understand the question, or the question has a number of possible answers. So the questions that are asked, and you don't ask, did you steal the 1,000 Rand out of the polygraph test? They're much more subtle. The framing of the questions is absolutely important. We deal briefly with the CWIU country meat market. It's a 2009 CCMA award, and that award, the commissioner goes through the law on polygraphs and attached very little weight to the evidence, and held that there's additional evidence apart from the polygraph test that is required for an employee to be proved guilty of the misconduct. In that case, the dismissal was found to be unfair and the employee was reinstated. Then the National Transport Movement and ZIFI versus Labour Hire CC. This is even more novel, where the employees were requested to pay for their own polygraph tests. So in other words, you prove that you're innocent by paying for a polygraph test, and if you come out clean, we won't dismiss you. And in that award as well, it was found that there was no justifiable reason for them to refuse the instruction, and they were not guilty of the gross insubordination. Their dismissal was deemed to be unfair. Then in Food and Allied Workers Union versus Premier Foods, it's a 2010 Labour Court judgment. The judge held, I am in agreement that polygraph testing as it presently stands can do no more than show the existence or non-existence of deception. That doesn't say you're guilty. It says, and I put it maybe too harshly, that you are fibbing, that there's something that is not quite right about your answer. Polygraph test on its own cannot be used to determine the guilt of an employee. In the context of an arbitration, the results of a polygraph can be taken into account where other supporting evidence is available. So I use the word corroborative. There needs to be corroborative evidence and not just the polygraph test. In the Mustek judgment of the Labour Court in 2016, this case involved the theft of a number of company laptops, and the court ruled that the CCMA commissioner made the decision that was reasonable in the circumstances, and that it decided that there was nothing that could corroborate the findings of the two failed polygraph tests, and therefore the employee could not be dismissed on an inference of guilt alone. So that's the only evidence that the employer had, was simply the failed polygraph test. Having said that, polygraph tests are very useful. I'm not saying throw them out, not saying reject them, but they need to be used very cautiously, and the person administering the tests needs to be properly qualified. The leading of evidence in the CCMA or any other forum needs to be properly presented. These polygraphers should be experts, and they should be dealt with as experts. In other words, a notice that you intend to call an expert needs to be given, a summary of that expert's evidence needs to be given, and they need to be called to the forum, to the CCMA or to the arbitration or whatever, to give evidence. And they need to be taken through that evidence carefully and thoroughly. They need to explain to whoever's hearing the dispute that they are experts, that they carried out, how they carried out the test, that they carried out the test in accordance with all sorts of international norms when it comes to polygraphs, and that these are the findings. These were the questions that were asked, and these were the findings, and that's why Joe Bloggs, the employee, was deceptive. And that evidence on its own is not good enough. There needs to be other evidence to corroborate, but that evidence needs to be properly put before the commission, not just simply the report, photocopy of the report handed up. Evidence needs to be led on their experience, their expertise, their qualifications, and the actual carrying out of the test and the results of the test. So I think that deals with polygraphs. I said I would be about 30 minutes. I think I've been going for 24 minutes. So I'm now going to talk about employees being dismissed for after-hours activities. So there were a number of cases before the 12th of July looting circumstances where it was held, and there had to be, the simple point is, there had to be a nexus between the individual carrying out the misconduct and the employer, be it whether they were wearing a uniform, whether they were representing the employer, or whether the actual misconduct had an impact on the employer. For example, if an article clerk in this office is caught speeding, it has absolutely nothing to do with his employment. If he is caught driving recklessly and negligently, and he's under the influence of alcohol, and he or she is on the side of the road shouting at everyone that he's employed by this particular firm, and he's going to get this firm to represent them at the criminal trial, then maybe there is an excess, and maybe those are grounds for a dismissal or some disciplinary action. But there needs to be this link between what the employee did and the actual employer. The looting, if I could just go out on a limb and say the looting was an extremely unusual and not normal situation. There were thousands of people involved in the looting. It was heightened, and we still don't know what the real reasons for it were. It was heightened by the issues surrounding the incarceration of the past president, Jacob Zuma. There are also clearly issues of poverty. There are clearly issues relating to service delivery. The circumstances are not clear as to why this happened. And a number of individuals, and I look back anecdotally to the young gardener who works for us, that a lot of people were simply swept up in the situation. And maybe the criticisms can go back to a lack of education and a lack of moral example by the leaders of the country as to why people did these bad things. But my own gut feel is that the young gardener here in our office is a good guy. And I wonder if I was in his shoes and I was frustrated by the lack of delivery. I had 2 kids who I was battling to feed. Sure, he's employed. He's not earning a fortune. But there's an opportunity to go and get a few luxury things that would make my shack in Mayville a little bit more comfortable, whether I would not also have looted. But it's, very difficult, and each needs to be looked on its own merits. So in the Hoogst CWIU Labour Appeal Court judgment of 1993, so we're going way, way back to the early days of the LRA. The fact that misconduct complained of occurred away from the workplace would not necessarily preclude the employer from dismissing the employee in respect thereof. But as I say, there must be a link, a uniform, selling the brand or something like that. Then we jump to the civil unrest of the 16th of the 12th of July. Can an employer dismiss employees who took part in that unrest? So back to the basic principles, we always go back to the LRA and to the Code of Good Practice on dismissals for misconduct. The first port of call is the dismissal must be substantially and procedurally fair. Substantively, a dismissal is fair only if it is for a valid and fair reason. And we all know, and those that have heard me talk before, I talk about our Constitution being a Rolls-Royce Constitution. It is an unbelievable document that came through an unbelievable process, and I think we should all buy into it and support it. And yes, I think it protects individuals' rights. On the right-hand side of that slide, and you would have seen on social media, there's a gentleman, he's got his face blocked out. If I recall correctly, he's coming out of the Woolworths on Botanic Gardens Road near the NSA. He is private school educated, and I think if I recall correctly, he was putting that basket of goodies into a Mercedes-Benz. He is also employed by one of the big national companies. I can't recall whether it's listed or not, but he has a big job in a big company. I think with the greatest respect, in those circumstances, there is little doubt that after a disciplinary inquiry, dismissal would be appropriate. I would certainly think that there needs to be evidence-led or the irretrievable breakdown of the employment relationship. So someone in the organization needs to give objective evidence on why this employment relationship has broken down. So Section 7 of the Code of Good Practice requires the following. Any person who is determining whether a dismissal misconduct is unfair should consider whether or not the employee contravened a rule or standard regulating conduct in or of relevance to the workplace. There's no rule against looting. If a rule or standard was contravened, whether or not the rule was a valid reason, the rule was a valid or reasonable rule or standard, the employer was aware or could reasonably be expected to be aware of the rule or the standard. The rule or the standard has been consistently applied by the employer, and the dismissal was an appropriate sanction for the contravention of the rule and standard. So our man with his basket leaving Woolies in Botanic Gardens, I would think that's a valid and fair reason to dismiss him. I think the circumstances of the gardener employed at our little office park in Problem and Keys certainly wouldn't be a valid and fair reason for dismissal. What is relevant in the workplace? And again, I just provocatively say, so the young gardener here in our office, he has access to our offices. All of us have handbags with wallets in, drawers with wallets in. There's food, sometimes alcohol on the premises. We all trust him, and that hasn't changed. So it would be very difficult for us all of a sudden to say we don't trust him and he should be dismissed. The test for relevance and the 1D layer and the CCM and others, it's a labour court judgment. The test for determining relevance to the workplace is that the employer must have a legitimate interest in the conduct or activities of the employee outside working hours or outside the workplace, and that there must be a link or nexus between the conduct complained of and the employee's duties, the employer's business, or the workplace. Then in the Fisher and Woolworths judgment, it's a CCMA award. The employee, senior person, was a manager at Woolworths, and she was arrested for stealing from a competitor, Truworths. Woolworths found out about the theft and conducted a disciplinary inquiry, after which she was dismissed. The CCMA held that a multifaceted inquiry must be conducted to determine whether the dismissal for misconduct outside the workplace is fair, which includes the following. 1, the nature of the misconduct, the nature of the work performed by the employee, the employer's size, the nature and size of the employer's workforce, the position of the employer occupies in the marketplace and its profile therein, the nature of the service rendered by the employer, and the impact of the misconduct on the workforce as a whole, as well as on the relationship between the employer and employee, and the capacity of the employee to perform his job. In the final analysis, what would need to be determined is whether the employee's conduct had the effect of destroying or of seriously damaging the relationship of the employer and the employee between the parties. And again, I go back to what I say, and often employers forget about this last tick of the box, is that there needs to be evidence of the irretrievable breakdown of the employment relationship. Certain things, if someone's found guilty, if an article clerk here is found guilty of taking 10,000 Rand out of the safe, slam dunk, we seriously don't need to produce evidence to say the relationship was broken down. It simply follows. But in these circumstances, in these difficult cases, there needs to be evidence of the irretrievable, just to make sure that all bases are covered. In the Hooft, the CWIU Labour Appeal Court judgment of 1993, and again, we're going way back, where misconduct does not fall within the express terms of a disciplinary code, misconduct may still be of a nature that employer may nonetheless be entitled to discipline the employee. Likewise, the fact that misconduct complained of occurred away from the workplace would not necessarily preclude the employer from disciplining the employee in respect thereof. And then the Hawu versus Barnes, or on behalf of Barnes versus the Department of Foreign Affairs, this was a 2001 matter. It involved an employee of the Department of Foreign Affairs. His behavior was absolutely shocking. He was on a flight to London and sexually assaulted someone on that flight. He tried to use his employer, being the Department of Foreign Affairs, to his advantage, put the department's name into disrepute. The CCMA held dismissal because there was a strong nexus between the applicant's behavior and the respondent's legitimate operational interest. So there needs to be that nexus. The connection between the employee's off-duty misconduct and the employer's business exists where the employee's conduct has a detrimental or intolerable effect on the efficiency, profitability, continuity, or good name and reputation of the employer's business. So I just go back and I keep harping on about our gardener. None of you out there know our gardener, would know his name, would know what he looks like. So it doesn't affect our brand whatsoever. If it was one of the attorneys working in the office that those of our clients knew because they came to the office regularly, and that person was photographed or video was flashed all over national TV, I have little doubt that we would be entitled to terminate that employee's contract of employment. So in conclusion, in order to dismiss an employee for conduct that occurs off duty, the employer must have sufficient and legitimate interest that is affected by the conduct or activities of the misbehaving employee. Thank you very much. I was 6 minutes over. So any questions?
Thanks, Dunstan. There are a few questions. So, you know, this whole thing with regards to the looting is obviously quite an emotive thing. So we've had a number of employees, or at least employers, that have found out that their employees have been involved. And it's obviously, you know, they've been directly affected by the looting. They have friends that have been affected. So it's quite an emotive issue. And we've had a couple of clients that have basically, what has happened is, I'll give an example where on the Monday, the employee couldn't come to work. And when he arrived on the Tuesday, he basically told the employer that he couldn't come on Monday because he was very sore from being hit by all the rubber bullets, because he'd been directly involved in the looting and he didn't see any issue with it. It was just one of those things. Now, where an employee has admitted to being involved in, let's take it away from looting, but admitted to being involved in criminal activity, so theft, whatever it may be, sexual assault, whatever, does an employer then, because there's no longer a requirement to prove their involvement because they've admitted it, does an employer then have a right to hold a disciplinary inquiry and possibly dismiss the person on the basis that they have been involved in criminal activity?
So we need to go back to square one. Employers need to ask the question at the interview, do you have a criminal record? And if the employee says no, and then it later transpires that they do have a criminal record, they have been dishonest. And that is a basis to dismiss them. But you need to ask the question. The other side of the coin is there needs to be, if you don't ask the question, you later find out that the employee is a rapist or a murderer or a thief or an assaulter or whatever, does it have, and I'm using the extremes provocatively, does it have any relevance to their job? So, for example, the lady that makes tea in the office maybe has a conviction for common assault and it's 10 years old. What relevance really does it have to her making tea in the office? Or she may have a shoplifting conviction. Then maybe it's a bit closer to hand because there are handbags, briefcases, and wallets that are in the office and things of value, and she is a convicted thief. She's been arrested, or been charged, convicted, got a suspended sentence for shoplifting. So to answer, each case, whether you're dealing with looting, needs to be dealt with on its merits, separately and individual, and there's no one cure fits all. One needs to have a look at it, and there certainly are circumstances where dismissal is appropriate. And I've given the two extreme examples and our other extreme example of the gardener at the office. And there must be numerous cases in between where it's not as clear cut as either of those. And the guy who comes back and says, he's clearly been arrested for looting, and he just says he saw for the rubber bullets. Well, maybe he's been a bit dishonest. Maybe there are grounds to take disciplinary action for the dishonesty, because he's not actually telling the full story of what happened. Again, our gardener, we sat him down when he got back here, and he told us the story from beginning to end. That's what happened. Yep.
Okay, perfect. And then just in terms of, so you brought up something with regards to, pre-employment checks, criminal checks and that sort of thing. One of the things that I've seen, I'm not a huge fan of it, but there are people that use polygraphs as a pre-employment check. And, in that they ask questions like, have you ever stolen, or whatever the story is. I'm not a huge fan of it because I think, as you've mentioned before, you could have stolen when you were, some chappies out of your mother's purse or whatever it was when you were 5. But using polygraphs as a pre-employment check to determine whether or not you can employ the person or whether or not the person is honest, what is your view on that? Well, so in this instance, we have a lot of people going to do pre-employment checks going, were you involved in the looting? And if they're dishonest.
Well, they're unlawful for starters, because pre-employment psychometric testing, any psychometric testing is unlawful, and you need to get an exemption to be able to do it. And particularly polygraph testing, the science and the accuracy of it is simply, not, and all that the test does, it simply says you're deceptive. And often, particularly in the multicultural society that we live in, the question may not have the same answer for all of us, So because I see, and that's why the questions are so important, and the questions may be orientated to some person's particular background, and the test is given to someone else, and they misconstrue the test, the question, and give the wrong answer, and they fail to get so they may well be discriminatory,
So, in other words, using a polygraph as a pre-employment check is not a good idea.
Not a good idea. Okay. Polygraph tests are very limited use, and certainly, and as I say, it's unlawful. You are not allowed to pre-test people. That's done all the time. A lot of recruitment consultants use various tests, but they are discriminatory because they are, for want of a better word, they are quite biased. They are. That's where they come from. They and our population is predominantly not white.
No. So we have a question here, which is from Tasneem, which says, does an employer have grounds to dismiss an employee if the employee obtains a criminal record? So they're actually employed. Whilst they're employed, they then obviously get a criminal record during their employment, for whatever reason. So assuming it's looting. So they've gone to, I don't know, they've been found guilty. Do we at that point as an employer have the grounds to have a disciplinary inquiry and discipline the person because they now have a criminal record for, in this instance, it would be theft?
Again, I go back to the main presentation. It needs to be relevant, but there needs to be a nexus. So again, I don't think that our gardener, even if on the 4th of September, when he goes back to court, is convicted of looting. And he, interestingly, he was eventually found, it tells us he was in the game store in town. He was picked up by the police near DUT. He had a brand new fan in one hand, 3 bottles of wine in another hand, and a couple of boxes of packet soup in his pockets. All things being equal, he's probably guilty. He's at least in possession of stolen goods. What relevance does it have to him working as a gardener here in Problem and Keys Road? The guy, the 2 private school educated guys, very, very different story. And, they are senior employees of their organizations. Yep.
So, I mean, from what you're saying is basically that, even when we do pre-employment checks from a criminal, so if we do a criminal check or a credit check, often we have employers that do credit checks, and it shows that someone has a judgment or and then on that basis alone, people decide they don't want to employ the person. Now, the reality is, and from what you're saying, is that you have to be able to go, one is directly related to the other. As a receptionist, during COVID, you didn't pay your TrueWiz accounts, sufficiently well, and now have a judgment. That doesn't automatically mean that you're a thief. Exactly. In other words,
and it may be different if I'm employing you as a CFO in a position of trust, and you have a string of judgments against you, and the probabilities are that you can't manage your own finances, and you are going to be looking at some possibility or some way of maybe supplementing your income to meet those judgments. I don't know, being provocative. That may be a different kettle of fish.
Yeah, I think the same would apply even again, we do criminal checks as an example, and often people are not employed because they might have a criminal record. But caution is, again, you need to take caution when determining that, because I would assume that in South Africa, once you've been found guilty and you've paid your dues, you're now, inverted commas, rehabilitated and to be punished forever and ever.
Exactly.
Yeah, so
you've done your time. Yeah.
Yeah, well, yeah. So there would have to be, as you say, a nexus between the two. So if you've been found guilty of rape, as an example, and you now work in a hospital with, I don't know, patients and whatever, there might be a direct link in there or whatever. Yeah. But if you were found drunk in public when you were 18 and you're actually a debtors clerk, there's no sort of correlation nexus there. It doesn't have any, yes. Yeah. And then I see that there's some other questions here, but just one. So you mentioned earlier in terms of polygraph testing is that, if you're going to be asking people to do regular polygraph tests, that it needs to be included in the contract. My understanding is even at the time when a person does a polygraph, the polygraphist has to get permission from that person. Absolutely. At that time. Yep. Now, what would be the consequences? Let's assume it's in my contract. I sign it because, I'm very excited about having a new job. And in 4 years' time, I now say, look, I actually don't want to do the polygraph. What would be that consequence? Because the polygraph is not going to do anything. But what is the disciplinary action that would be taken?
Well, you've agreed to it. So it's a breach of your contract. On its own, probably not dismissible. Depending on your position, depending on the circumstances, but it's certainly misconduct because you've agreed to, and then I go back to the adverse inference. I must draw an inference from the fact that you're now suddenly refusing to undergo a polygraph test when there are these allegations of misconduct against you.
Mm. Okay. And then we got a question from Anton. What he's asked is, could you please explain how pre-employment polygraphs are unlawful? Which laws, or it could be case laws, prohibit these examinations?
Okay, so there's a blanket prohibition on psychometric testing. And secondly, there's a constitutional right there. I cannot force you. Likewise, as we have now with COVID vaccines, there's no law which says you have to have a vaccine. There's no law which says before you take up employment, and it's an invasion of your privacy. You are putting all these probes and things on my body to test my reactions, and with the result of it has discriminatory and failings. It's not an accurate science. So at two levels, you can't use polygraph. They are used, and many employers do, and many recruitment consultants do. But they are discriminatory. If someone picked up a class action on them, they would put a stop to it. It's just that there's no resources and people don't have the funds to litigate before they've even taken up a job. They say, well, I was refused employment because I refused to do a polygraph. No one's going to take up that case, but it is unlawful.
Thanks. So just as a last question, I don't know if there's any others. So you spoke about psychometric testing, and when we talk about criminal checks, credit checks. In any event, if you're going to do these checks on a new employee, these must be, if you're going to take them into account, have to be a very small part, I would assume, of your decision to either take or not take that person. It cannot
Absolutely.
be the sole determiner.
Yeah.
So psychometric tests, if you're going to do discus or Thomas International, any of those things, it has to be only one element of the greater process in determining whether or not you take that person.
Yeah.
Okay. All right. Well, I think that's it for us. I don't believe there are any further questions. I want to thank you for your time this morning. It was very informative. And then just to say to the participants, the webinar will be available in a few days' time. It will be up on our website. And if you have any questions, if you need any further information, you can email info@HRTorq. And if you have any questions for Dunstan, do you want to just share your email?
Absolutely. Yeah, dunstan@farrell.co.za. Very happy to answer any questions.
Perfect. Thank you so much for your time.
Yep.
Thanks, everybody, and have a good rest of the week.
Yeah, and thanks for listening to me.
Thanks. Okay, bye.